On 18th of April, at the International Criminal Court in The Hague, Judge Ekaterina Trendafilova, designated single judge of the pretrial Chamber 2, held the second status conference in the Kenya situation. The three suspects, Francis Kirimi Muthaura, Uhuru Muigai Kenyatta, and Mohammed Hussein Ali, were represented by their respective defense teams at this hearing. Adeshola Adeboyaje, the trial lawyer from the Office of the Prosecutor, informed Judge Trendafilova that the prosecutor intends to call 10 witnesses to testify and submit 3,100 pages of full witness statements during the confirmation of charges hearing.
Now I turn to the defense teams. First, to ask you whether you would like to make some observations to the information that was right now disclosed by the representatives of the prosecutor, and whether you yourself consider presenting evidence at all, because it is the right of the defense just to remain silent.
It is as well to say at this stage that the defense for Mr. Muthaura say that not only will these charges not be confirmed, but that it is a travesty of the highest order that he has been summoned in the first place. And so it is our intention to vigorously contest the charges and to present evidence. There hasn't, with the greatest of regret, there hasn't been a single case where the confirmation date set has been abided to. And in the overwhelming majority of cases, the record discloses that is for one simple reason: lack of disclosure, lack of timely disclosure by the Office of the Prosecutor. Now, Your Honor, I'm not gazing into a crystal ball, but if we are to avoid the same consequence of a non-effective hearing on the 21st, it is incumbent upon the prosecutor to do that which he's obligated to do, not to hide behind admissibility challenges, not to hide behind other arguments, but in good faith, and we of course expect good faith from my friends opposite, to give disclosure in a timely manner.
Mr. Kay?
Thank you, Your Honour.
Yeah.
On behalf of Mr. Kenyatta, we will be challenging the confirmation hearing. As yet, we have not seen any evidence of any significant or substantial nature, as Your Honour knows. So I'm unable to give the court any idea of the nature and structure of the materials that will be presented by the defence at the confirmation hearing, nor how long it will take, because such decisions are predicated on what is served.
Thank you, Mr. Kay. Finally, the representatives, the counsels for Mr. Ali. Is Mr. Munari going to speak?
Yes, Your
Okay.
Honor. Likewise, we will be vigorously opposing at the confirmation hearing the charges that have been laid out. However, without full disclosure of any material to date, we as a team are unable to indicate to Your Honor as to how many witnesses we will call, which types of witnesses, and which documentation we will rely upon.
You are aware of the fact that the Chamber issued the disclosure decision on the 7th, so that in no way it would be the contribution of the Chamber to delay these proceedings, because we are seized with two cases, and we are very much aware of our responsibilities to respect the principle of expeditiousness and to respect the rights of the defense.
The Office of the Prosecutor announced that it is in the possession of 219 documents and about 5,400 pages constituting material evidence in this case. The Office of the Prosecutor also indicated that the documents will be submitted to the Chamber with a request to approve reductions before disclosure to the defense.
The prosecutor estimates that it would disclose approximately 542 documents in redacted form, of course, as Your Honor has rightly pointed out, subject to your approval, and this would constitute approximately 9,397 pages.
Thank you. Do you consider approaching some of the witnesses with protective measures.
The short answer to that is in the affirmative, that the prosecution has sought and continues to seek protective measures. As far as the prosecution is concerned, protection of witnesses is cardinal, and the prosecution has taken great care in consultation with the Victims and Witnesses Unit to protect all persons with whom it has come into contact during the course of the investigation. And this has also included minimizing its contact with those remaining in the country. However, it can only be underscored that there is a limited capacity to protect individuals in the country, particularly where the suspects remain in positions of power in an environment where witnesses could run the risk of disappearing or otherwise becoming uncooperative before testifying. So for these reasons, the prosecution's position is that the disclosure of documents containing sensitive information should take place only after protective measures are in place and a final decision is made on the challenge to admissibility. The prosecution is, however, willing and able to provide disclosure of other materials before that time, and this is, of course, respecting the needs of the victims and witnesses whose identities should not be revealed until the case has been found to be admissible. Your Honor, we would also be providing more detailed written submissions in this respect soonest.
But for the prosecutor, in his public protestations that are before the bench, and today again to refer to the public duties that my client holds, the public service he has provided over decades to the Republic of Kenya, and somehow seek to make innuendo that it is somehow sordid or somehow places witnesses in jeopardy, is to malign not only an individual that is presumed innocent, but is to put a cloud of innuendo over these proceedings. And, Your Honor, that cloud of innuendo and suspicion, gossip and hearsay, has the potential, and I make no bones about it, to severely prejudice defense investigations.
I am concerned about statements being made concerning the suspects being in power and linking that in a very unstructured, unfounded way into this issue. And we're concerned about that, and I would invite the prosecution to be very mindful of such public statements when in fact they are not linked to the matters that we're dealing with and have no foundation, because they do cause great difficulty for the defense. And who knows, maybe I'll get back to Nairobi and have another week of trying to deal with false stories that are put into the newspapers. And I ask the court to be mindful of media manipulation.
With regard to your concerns related to extensive reductions, of course, you know that it is the responsibility finally of the chamber whether proposed reductions will be accepted. So it's our responsibility. At the same time, we have to acknowledge that there should be a balancing approach between two important values: the respect and the concern and the responsibility of the chamber regarding the protection of some people who might be at risk, and at the same time that it doesn't have a negative impact on the proper preparation of the defense. So finally the decision will find a balancing approach, and reductions will be accepted only to the extent necessary to protect people's life. With regard to your statement that there appears to be competing powers, there is a chamber. As long as the chamber is seized of a case, it's the power of the chamber to take a decision and the responsibility to take the proper decisions and to be responsible for the consequences of this decision. With regard to the admissibility challenge, the parties will soon see a decision to be issued on this matter. And finally, about the media, The aim is just to send some messages in order to avoid some complications. That was all.
The Office of the Prosecutor also has an obligation to disclose to the defense potentially exculpatory evidence in its possession.
We are looking at 292 documents, which would amount to 9,929 pages of potentially exonerating materials. And I do thank Your Honor for the clarification that formally we were referring to materials which were of a protected or confidential nature.
Judge Katarina Trendafilova announced that the Chamber will issue a decision on the disclosure calendar in this case soon.